Hello, everyone. Welcome. For those attending, we're going to get started here momentarily. I'm going to share my screen here so we can get started. We usually like to give like a minute or so in the beginning for everyone to kind of get in, get settled before we fully launch into it. Let's see here. Can you see my screen? All right, perfect. Okay. Let's give it another minute, and then we'll get going here. Um, Looks like we have a good turnout here. I just realized if you registered for this webcast in the last day or two, good on you for not being deterred by the date on the landing page being for last week. It is today, so you're in the right place. Um, but we are going to be getting going here now. We're a minute past. I think most people are pretty punctual nowadays, so um, let's get going. All right, welcome to the Build Fellowships presentation. We're going to be talking about immigration solutions today for the world's top talent. We're going to be discussing a lot of things. Um, my name's Ian Davis. I am the Director of Partnerships here at the Build Fellowship. I've been working in the world of immigration, global mobility, international education for nearly 20 years now. I'm joined by my colleague, Michael Cruse. Michael, is here. He's the Immigration Program Director. You want to tell everyone about yourself, Michael?
Hey everybody, I am Michael Cruse. I am, as Ian said, the Immigration Program Director at the Build Fellowship. I've been with the company about 2 years now. I am, by training, an immigration lawyer of over 20 years. Most of that time spent in big firms, corporate environments, but doing only employment immigration law. So this has been a really cool transition for me.
Good. Well, I appreciate you joining us here today, Michael. Taking a look at this agenda. We've got a couple of items that we're going to go through. First of all, we're going to talk just in general about the H-1B work visa here in the United States, give kind of a general overview of that. And then we're going to dive into some current events. Some of you here may be up to speed on some of this. We're going to talk about the recent court ruling that took place on Monday with regards to the H-1B presidential proclamation. We're also going to discuss some of the proposed changes that have yet to be signed into law for F1 and the Day 1 CPT programs. And then we're going to also kind of finish the presentation talking specifically about Cap Exempt H-1B visas and the Build Fellowship and how this might be a creative immigration solution that is best used for some of you here today. So without further ado, first go back to this. I want to let everyone know there's a chat function and I believe a Q&A function here in Zoom. If you type your questions in during the presentation, I will try to answer some of them as we go, right, live. I'm sure some of the questions we actually might get to later in the presentation. So if we don't answer them right away, we will absolutely get to them. And if it's not a part of the presentation, if we have time at the end, we'll go through some Q&A if things were left unanswered or if people have new questions. Okay. All right, so let's talk first in general here about H-1B visas, right? So the H-1B visa is the most common work visa in the United States, and it's specifically for, or I should say, it's the most common work visa specifically for highly educated, highly skilled foreign nationals living and working in the U.S. Most of you here are likely familiar with the H-1B visa lottery. That's how most people know about H-1B visas. It's a lottery that occurs once per year, typically around the end of March, and 85,000 visas are distributed through the lottery system. They cap the number of visas at 85,000. So the H-1B lottery is oftentimes referred to as the cap subject H-1B. And so we're going to be talking today using terms like cap subject, cap exempt. That's where that phrase kind of comes in, that term 85,000, it's capped at that number. And then for those who enter, the selection rate traditionally has been around 30%. This year, we did see a slight uptick in that due to lower enrollment for some environmental factors like this H-1B proclamation we're going to be talking about later on, et cetera. And so we will cover all that. Um, and so this is kind of the general idea. Most people understand the H-1B being, right? So what is the basic requirements to potentially secure an H-1B work visa in the US? Well, number one, you have to have at least a bachelor's degree, master's, PhD, or the equivalent in a STEM or business related field. Okay. If you are here today on a STEM OPT, chances are you probably qualify. Okay. If you do not have a degree in any field or not in the field that you are applying for the H-1B for, you can get what's called a workplace equivalency evaluation, which basically is a way to show that your experience working in this field is equal to that of a 4-year degree in that field. Okay. So if you don't have a degree, but you spent 20 years working as a, engineer at a manufacturing plant, that might be something. If you do have a degree in, let's say, French literature, but you've been working in finance for the last 12 years, you might be able to get an equivalency to show that your experience in the last 12 years is equal to that of a degree in finance, something along those lines, right? But then you also have to have a job offer from a U.S. employer, okay? Because this is a work visa. This is not just like a general visa. It's related to your specific skill set. This job offer can also be from a company that you own. So we have maybe some of you here today are looking at creating your own company, like your founders, entrepreneurs, things like that. As long as the position is in your field of study, that's something that you can do. Here at the fellowship, we actually have quite a few founders participating in our fellowship right now, because there's some limitations on what you can and can't do with creating your own company on other visa types. And so H-1B is really kind of ideal for those who want to work. So that's the general requirements. Let's talk a little bit about what comes into play with the H-1B timeline, right? Because the lottery is once per year, but it pretty much is something that goes on year round in terms of like preparation and positioning for the lottery, right? So typically starting around the fall is when most companies start doing their annual planning for the next year, right? That's when they start identifying growth opportunities. They want to look at employment numbers, looking at retention, these sorts of things, and kind of evaluating internal and external candidates potentially for roles that may become available or may need to retain the following year. So typically between the fall and I would say around February or so is when companies are prepping. And then come March is when H-1B registration begins. Okay, so there's a window of about 2.5 weeks where employers or the attorneys representing them can register a candidate online for the H-1B lottery. Okay. That's the first official step to kind of put yourself into the lottery, right? You can't self-petition unless you have your own company. Typically, this is done by an employer, right? Or the attorney. Whereas if you own your own company, you can. But if you're just an employee at Microsoft, you can't put yourself in the lottery for Microsoft, if that makes sense. So that registration takes place in March, and then at the end of March, first day or two of April is when the lottery selection occurs. Okay. I think this year was 3 days, 4 days, something like that, where they started posting lottery results. Those notifications are posted and typically are sent to the employer or the immigration attorney that did the filing. It is not sent to the employee, because just because your name was selected in the lottery doesn't mean you automatically get an H-1B visa. Once your name is selected, your employer still has to file an H-1B petition, I-129, and a labor condition application. Okay. That's what's going on right now. Okay. So the deadline for companies to file the H-1B petitions for those who won this year's lottery is June 30th. So every immigration attorney you're talking to right now that works in employment law, they're busy prepping up these H-1B petitions, right? Because June 30th is the deadline, right? So results are posted the first day of April around approximately, and then you have more or less 3 months, 2.5 months to prepare the petition before filing. Once the petition is received by USCIS, they go through a review process, they adjudicate the petition, and then typically, if approved, the visa it begins October 1st. Okay. Now I say typically because if you file an H-1B petition with USCIS, they can always issue what's called a request for evidence, where they are looking for more information about the petition, about the individual's background, about, making sure that they had a clean maintenance of status, like all of these things, right? We have had some fellows who won the H-1B lottery, but did not receive the visa until well into the new year, February, March of the next year, right? And so while that's not common necessarily with this current administration, who knows, right? And so it's something to kind of be prepared for, to be diligent, to continue to push things forward. But then October 1st is when those visas are issued typically. And it's a little confusing because the lottery that occurred this year in March of 2026, the visa is issued in October of 2026, but the lottery was called the fiscal year 2027 lottery. So there's a little bit of confusion there, because it's for the following year, but you get the point. Michael, did I miss anything here?
No, you nailed it. Great job.
Great, thanks. Bar me right now.
Yeah.
All right, so many of you are here today, probably not only because you're just genuinely interested in the Build Fellowship and Cap Exempt H-1Bs and maybe some alternatives to the standard lottery, you're also probably here to get some information on what's been going on currently in the news with all things related to immigration. There's two kind of key areas that we wanted to discuss today. One being the court ruling from Monday that impacts the presidential proclamation that was made in September 2025 regarding H-1Bs and a H-1B fee that was paid for consular processing. And the second part is proposed updates that have yet to be signed into law that will impact F1 statuses and Day 1 CPT programs. Okay, so let's start with the H-1B proclamation court ruling. See if I can give a good summary here. So back in September, this administration, President Trump, made a presidential proclamation. I studied political science in college. I had never heard of a presidential proclamation before.
It was a new one for me too.
Right. So proclamation saying, okay, for all H-1B petitions filed for those outside of the United States, they have to go through consular processing to receive the H-1B stamp and enter the U.S. We are going to impose a $100,000 fee to process that petition. This fee did not impact those who are already in the United States filing what's called a change of status petition, right, or adjustment of status. So if you were here on an F1, J1, L1, H4, whatever it may be, you were in the US and you filed an H-1B petition, this doesn't apply to you. Okay. The vast majority of H-1B petitions actually are change of status. Internally for us, about 90% of all of our petitions are change of status. But if you are outside of the US, there's this 100K fee. And this really impacted a lot of major employers in the US, especially those who look to bring in foreign talent into the US to fill vacancy, right? That they can't fill with, local workforce. So what happened on Monday, and this is one of several court cases that was going, a federal judge in Massachusetts ruled that this $100,000 fee was an unlawful tax, right? It exceeded the powers bestowed to a president and was viewed as a tax, and taxes are the responsibility of Congress. And so he went above and beyond his legal rights to do that as the president, right? So this is an unconstitutional tax. Previously, H-1B fees were between $2,000 to $5,000, kind of in that range. So as you can imagine, a spike to $100,000, pretty substantial, right? There are currently two more cases against the $100,000 fee that are still pending. The Chamber of Commerce one, I believe, just used the summary judgment here in their case. And And so why is this kind of relevant and important right now? Well, number one, as we mentioned before, June 30th is when all of these H-1B petitions have to be filed. So if anyone's outside of the United States right now, they want to have everything in by June 30th. And if they're going to have to pay or not have to pay $100,000 for the petition, they need to know that now because it's June 11th at the time that we're recording this. Also, there's opportunities here for the Department of Justice to file an appeal and kind of delay the process. They announced earlier this afternoon that that's something that they plan on doing. Now, this proclamation was set to expire in September of 2026 anyways. And so we will see as the days and the weeks progress what is to come of this, right? Now, Michael, if you could maybe explain like what could be a couple of potential outcomes, starting with the most favorable for those who are looking to file an H-1B petition and not have to pay $100,000, and then to the least favorable.
I mean, the most favorable situation would be they just decide, the Trump administration decides not to appeal this. If they're looking at the calendar and they see September is when it's set to expire anyway, they see that there's movement against the $100,000 proclamation and the fee. They see that it's already been deemed unconstitutional, Anti-Administrative Procedure Act. The next two courts will likely use this as precedent to do the same thing. It's not going to be popular to try to appeal each of those cases, and it's going to cause all sorts of chaos. And so I would like to think that would be what they would do, but I don't know that that's the case. I think they'll probably appeal. They're probably going to request that the vacate decision from this judge to vacate the $100,000 fee will be stayed, which means we go right back to having the $100,000 fee while the appeal is pending. Then maybe another case does the same thing that this judge did, and then we don't have the fee anymore. And then it goes back to the fee again after an appeal. So, I mean, it could be very chaotic in the next couple of months. A lot of attorneys, I mean, this is very new. A lot of attorneys have been talking about the idea of just not doing anything at this point. I think a lot of people got excited. They wanted to file cases right away. There's employers, like Ian was saying, that have 2 to 3 weeks left to file petitions, including some of our fellows are in that boat. And we want to do that. But what happens if it's pending and then the $100,000 fee comes back and then you get an RFE for $100,000? None of this makes any sense. I've been doing this for many, many years, and I've never seen anything so arbitrary as this $100,000 fee. And I think a lot of us expected what happened Monday to have happened months ago. And it's really shocking that it's taken so long to get to that point. But it is a good sign. And hopefully this means that we're sort of going to see it fade out. Until then, though, I think the prevailing advice from people around the country is we don't know what's going to happen within the next few days, because if the Trump administration appeals right away, which they said they were going to, and they get a stay of the $100,000 fee, you just filed it, and now you're owing $100,000. And so it's a really big challenge at this point to really know what to do, and the time is running out. So my gut says that we're going to end up with a lot of chaos and a lot of people get stuck.
Which seems to be the motivation for this current administration, right?
I
Muddy
think,
the water as much as possible.
Exactly. I think that this proclamation was arbitrary. It was half-baked. It wasn't really thought through. And to this day, we don't even really know how to get an exception to this. They talked about exceptions. We've applied. We've all gotten denied. Everything has just been so unclear, but it has resulted in significant chaos, fear. A lot of employers have reported that they are now rethinking their immigration plans because they don't want to get caught up in such chaos or end up having to pay $1,000 or $100,000. And a lot of foreign nationals are looking elsewhere as well, because it's just too much to have to deal with this after being in school for 4, 6, even 8 years here in the United States and then getting thrown this. Most people, though, are able to find a way to change status, which has been really good for us. We've been able to help people do that without having the $100,000 fee. So if you have F1 status, You can maintain that F1 status until it's time for an H-1B. You should be able to avoid this if it's still in place when it's time for you to get an H-1B.
Yeah. And the unfortunate thing is some employers who maybe weren't even impacted by this because their employees were all domestic, they weren't trying to bring anyone in.
Right.
They assumed that maybe this applied to them and this influenced their decision on whether or not they're going to support their employees and put them in the
Yeah.
lottery. And so if you're here today and you have a manager, an HR leader, a boss that is uncertain about immigration because of just like the chaos that seems to be coming from the news in this administration. This proclamation only applied for those outside of the US. Okay, so if you're here, doesn't apply to you. Okay, never did and seemingly won't. Okay. All right, so that was the first thing we wanted to talk about. So I guess the moral of the story, the first one to wrap it up, put a bow on it. We'll see, right? The next couple of days and weeks should be very, very interesting. And just kind of stick stick around and tune into all things Build Fellowship because we always kind of push out the information as soon as we get it. The next thing is these proposed changes, right, to F1 visas, F1 maintenance of status, day one CPT programs. So there's two things here, and Michael, I'm going to let you expand on these, but from what I gather and what reading through these proposed changes that have yet to be signed into law. Number one, first change is restricting the switching of programs or degree levels. And so this would maybe impact those who are in an F1 program, could be a standard F1, could be like a day one CPT program. And they're like, okay, I've been in this program for 2 years doing a degree in computer science, but now I want to switch to, a master's of business administration, right? That may be prohibited. Or, hey, I already have my master's degree in computer science. I'm going to do a day one CPT program because I didn't win the H-1B lottery for my MBA. And that comes with work authorization. So even though I have a master's in computer science, I'm now going to enroll in an MBA program. It's going to make me more marketable, but it's also going to allow me to continue to work. That lateral enrollment in the same level of education you already having the master's and doing another master's program will be prohibited. You can only go up from there, right? The second change is more about the fixed I-94 end dates. So this has to do with the duration of your F1 visa being limited to 4 years for everyone. And then if you want to do a master's program, even a regular master's program, not just a day one CPT program, you would have to apply for an extension of your F1 status through USCIS to be able to do that. So why don't we start with change number one? Michael, did I describe that correctly? Like, what is the kind of like the more intelligent description of that?
No, you did a great job. I think, the thing about F1s is they were always sort of very flexible. Once you got to the US, you had no end date. You had a duration of status as your end date. And so any changes that you wanted to make, you didn't have to go through USCIS or the embassy. You already had an F visa, you're already here, you already are in status. And so you would just go apply to a new school. You would apply to, let's say you didn't like the program you were in at the University of Cleveland, right? And then you apply somewhere else and transfer, and it's all handled internally by the schools through the SEVIS system. It is a government system, but it's not USCIS. So you didn't have to do anything about your status. You were assumed to be in status as long as your SEVIS record was updated and accurate. That could be switching programs, that could be, switching or doing 2 master's degrees in a row. Whatever you wanted to do was technically approved. If you left the country and had to go to the embassy to renew your F, then you could face some scrutiny and they could ask you some questions about why you're doing another master's or an MBA when you are a computer science person or something. But it was generally pretty flexible. And that's important for students because they're constantly sort of flexing and changing and going in different directions. And something could take you to another school or another degree program. That is all going to be, it remains to be seen how USCIS is going to look at requests to change programs or to extend. in the United States, it seems like it's going to be pretty difficult. I mean, they're doing this on purpose because they're trying to get rid of that flexibility that was built into the F1 program. So you
Yeah,
want to
I'm
talk about change
sure.
number two, then?
Yeah, I think just to the bigger picture of change number one, a lot of companies and a lot of foreign nationals kind of rely on the ability to enroll in a day one CPT program to maintain their work authorization, right?
Yeah.
If you don't win the lottery during your OPT or STEM OPT, you're looking for another solution. Begrudgingly, sometimes they may enroll in another master's program, right? Sometimes there's a genuine desire to level up, right? Continue their education. But unfortunately, the spotlight is on those who had used this program as just a way to extend work authorization. And now everything is kind of being caught up in that. Um, and so we will see how this impacts some major employers as well. I've talked to, hundreds of employers over the years that employ rely on this program for a lot of their employees domestically, right? And so we'll see how that goes. So yeah, let's talk a little bit about number two, fixed identity foreign dates, potential gap in work authorization. You kind of talked a
Yeah.
little bit about this. But I guess what is, in your opinion, what is kind of the risk of having a set I-94 end date?
Yeah, I mean, so what they've announced that they're going to do is give a 4-year maximum on, let's say, a bachelor's program. So it's already hard enough to squeeze in a bachelor's program into 4 years, even if you're doing,
I'm gonna just say it. I finished my bachelor's in 5 years.
I was 4.5. I
There you
mean,
go.
and I was full time. So I mean, it's difficult unless you're going to a very regimented school and program. If you're at a big liberal arts school, you could be just kind of roaming around and not know all of a sudden 4 years have passed by. But anyway, these are students that plan out. They're paying full fare. They're getting F1 visas to come over, and now instead of DS, they're going to have an end date, which would probably be like May something of their 4th year, and that's when they're expected to finish their F1 studies. Now, what that doesn't include is that OPT, that everybody, that sort of golden ticket into sort of transitioning into the US workforce once you finish a bachelor's program or a master's program in the United States. So they're suggesting the USCIS will have to review a request for an extension of your 4 years just to have OPT status. So you're going to have to apply, and this is all still, we're not sure how this is going to work, but it sounds like you're going to have to apply for that extra year toward the end of your 4th year and have a very good reason why you need to remain in the United States after your program ends to work. I think that there's always been, I mean, for many years now, there's been crosshair. I mean, the CPT program has been in the crosshairs of USCIS for many years. There have been a number of bad actors in that realm. There have been schools that have gotten in trouble for not genuine day one
Pay to
CPT
play,
programs.
kind of, yeah.
And so they've kind of ruined it for everybody else, even though there are some legitimate cases. We have a lot of fellows that come in with day one CPT history, and we're able to get them into H-1B without a problem. There have been many issues there. And so that's been on the chopping block. So the change one doesn't surprise anybody. And also change two includes that day one CPT. How are you going to go to the embassy now and apply for a master's program at one of the day one CPT universities and justify that, much less get an extension of your F1 status into a day one CPT program? I have a feeling that the USCIS is not going to look favorably on those extension requests, but also the DOS is not going to look favorably upon those visa requests at the embassies abroad. So this could be really problematic for a really important um, part of the pipeline of the U.S. labor force, which is foreign students. And it's already hit us hard this year with a significant decrease in visas issued. But this is also going to hit us when people are not able to stay and extend, do OPT, and they're paying full fare, which is just incredibly unfair because it just I'm not sure how this is going to go, and we're all really frustrated with this particular rollout.
Yeah. So where are we at with this? It's currently not signed, right?
It's not, but it's expected probably later this year.
Okay, gotcha. So if you are considering a day one CPT program, or if you're in one, or if you're considering just a master's program in general, right? Not even a day one CPT program, there might be some urgency on this. And we will see on how things kind of shake out. I know it's not a satisfactory answer for both of these current events, like time will tell, but this is kind of where we are at June 11th, 2026. Okay. Thanks, Michael. All right, so let's talk a little bit then about some alternatives to both the standard H-1B that you get through the lottery and also a day one CPT program, and that is cap exempt H-1B work visas. Okay. So as I mentioned earlier, the visas distributed through the lottery system are oftentimes referred to cap subject H-1Bs because they cap the number at 85,000. Congress, back in 2000, I believe, created a separate designation for organizations in the United States, and they use the term cap exempt. Okay. So what cap exempt means is that there are organizations in the US that can file H-1B petitions at any time during the year. So they're not subject to the lottery. So Yash, one of the questions I see it here, you asked if the cap exempt H-1Bs are issued in October as well. No, because we can file these. I mean, yes, they can be issued in October, but they can be issued year round because we're not cap exempt H-1Bs are not tied to the lottery system. Okay. So anytime during the year they can be filed. And the same qualifications apply to the cap exempt H-1Bs, the cap subject H-1Bs, including this presidential proclamation. This is a common question we get a lot, like, oh, if we file a cap exempt H-1B, I'm outside of the US, does this 100K apply to me for my consular notify? Yes. So it doesn't matter if it's cap subject or cap exempt, consular notify petitions are subject to that 100K. What is not applicable to cap exempt H-1Bs is something that changed this year in the H-1B lottery, which was wage levels, right? So for many of you here today who were in the H-1B lottery, there was a weighted lottery this year where your prevailing wage level 1 through 4, either gave you a higher chance of winning the lottery if you had a higher wage level. The simple way to explain it is if you have a wage level 1, you get one entry, your name in the hat once. If you have a wage level 4, your name's in the hat 4 times, right? And so the idea with this administration was to reward those that have higher paying jobs with a higher probability of winning the lottery. Okay. That doesn't impact H-1B cap exempt petitions at all. Okay. So there are 4 types of organizations in the United States that are considered cap exempt. Number one, the most common of all is public universities, right? University of Michigan, Cleveland State University, really any university that's a state college, public school is cap exempt. You then have government research organizations. You have nonprofit research organizations, and then you have nonprofits that are affiliated with universities. One common misconception is that any nonprofit is considered cap exempt. That is not the case at all. And just because you're a nonprofit works in some regard with a university doesn't necessarily make them cap exempt either. There's certain requirements that they have to meet in order to have that status. Okay. But these are the 4 types of institutions that qualify for cap exempt status. So with all of these organizations, there is an opportunity for an individual with a cap exempt visa to work concurrently for a for-profit cap subject employer. And that is through this company, this for-profit company, filing what's called a concurrent petition. Okay. So as long as the foreign national is working at least 5 hours per week for the cap exempt organization, a cap subject employer can file this concurrent petition, which allows them to employ this foreign national on the cap exempt visa. Okay. So the legal basis of the H-1B cap exempt visa is the 5 hours plus that they are working for the cap exempt organization, but then they can also work up to full time for a CAP subject organization as well. Um, and that's the model that we have here at the Build Fellowship with our Cap Exempt Fellowship. We work with highly skilled foreign nationals, and we develop with them experiential learning projects that are based on their specific area of expertise, right? We have partnerships, our nonprofit has partnerships with 16 universities across the United States. The projects that we develop with our fellows are offered to our university partners for students at those schools to apply to and participate in and study underneath these fellows as a way for these students to gain some practical knowledge in a field that they are eventually going to work in, right? So if you are a software developer, you have a master's in computer science, you've been, writing code for a while, the students that are applying to your project are also studying computer science, right? And they need to fulfill internship requirements. They need to get some practical experience because eventually they're going to want to work in the same role that you have now, right? So fellows at the Build Fellowship work for 5 hours per week leading this experiential project. And then a full-time employer files the concurrent petition, which allows them to continue to or start to work for this company on this same cap exempt H-1B. Okay. The idea or the most common pathway for the fellowship is typically retention by the company. A lot of times the foreign national has been employed by an organization for a while, maybe on their OPT or STEM OPT. They don't win the lottery. They're looking for a creative solution, right? That's where the cap exempt fellowship comes in, right? They're debating between that, maybe doing a day one CPT program, maybe nothing at all. Maybe they have to move overseas or whatever it may be. And so the projects that our fellows lead are really specific to the industry that they work in, right? Because H-1B is a very narrow focused work visa, right? You have to have the qualifications for it. And so the project that our fellows lead are very specific to what they do. The students from the universities that we work with represent just a portion of actually all the universities that participate in our project. So we have 16 universities where we partnered with. Those students get first priority in applying to projects. Last year in 2025, we trained just over 1,300 university students from 54 different universities. Okay. And so we limit the number of students per project to 15. So if a project isn't full, students from outside of our university network can apply as well, right? If it is full, if we get 20 applications for the 15 seats, first priority goes to those universities that we are currently partnered with, right? So it's really, really beneficial. And the project, the fellowship is fully remote. So you can do this from anywhere in the country. You're not on campus anywhere. Many of you here today maybe were like a TA in college, something like that. That's not the case, right? This is something that you will be doing from home in addition to your normal job. Okay. Looking at some of the universities that we are partnered with, some of these are household names that some you may recognize, Vanderbilt, George Washington University, Ohio State, from Michigan. No, I don't really mean that. Ohio State, you're great. Holt Business School, all of these places, right? But we also work with some regional universities like Grand Valley State College in Michigan, and even some technical schools and community colleges, right? So the roster of students participating in these projects is very, very diverse. And the companies that we work with are very diverse as well. We have fellows, a lot of them are in a STEM field, many are in business, law, finance, things like that, but they're all over the place. Some of them are large multinational organizations. Some of them are bootstrap startups and everything in between, right? The one common factor is they have talent that they are looking to retain or recruit that is going to move the needle for their organization, right? Companies value the talent that they have developed, especially if you've been working for an employer for a few years now. Study after study will show that the cost of retention, even participating in a program like the fellowship, is always less than the cost of replacement, right? Not only in recruitment fees and, compensation, but just institutional knowledge loss alone. So the organizations that we work with are industry leaders that really value talent and keeping talent and recruiting new talent. So some of you here today maybe on an OPT, right? Or maybe on some other visa that's going to be expiring relatively soon. Or good for you, you're doing your research ahead of time. We love that, right? Or you're like, oh, I actually have a year left. I got one more lottery attempt. Congratulations. I'm very happy that you are here. In fact, the question that just came in is, I'm on STEM OPT expiring in January 2028. Anonymous attendee, thank you for showing up a year and a half
Yeah,
early, right?
we
Um,
like that. Yeah.
we do like that. I love all the fellows that I work with, but a lot of the people I'm talking to this time of year have OPTs that are expiring in like 6 weeks, right? And so it's go time. And so here's kind of a general overview. If you were to participate in the fellowship, what the timeline looks like for securing a cap exempt H-1B. Generally speaking, if we're doing a change of status petition, which we mentioned earlier is the majority of the petitions we filed, from start to finished, usually takes between 8 to 12 weeks. And that's if we don't face any delays. Okay. So what's involved with that? First is we go through a consultation. We talk with the company, we talk with the employee, the foreign national, we go through the process. We then collect relevant documentation, transcripts, diplomas, work history, immigration history, passport pages, job description, everything. That information is used by Michael's team to conduct an evaluation to determine, number one, is this just a viable H-1B case, right? If it's not viable, if we think any reason USCIS is going to deny this petition, we don't move forward with it, okay? This is why this is the first thing we do. Before a contract is signed, before anything is paid for, we do an evaluation, okay? If we're confident in it, we determine what especially the occupation code is going to be that we'll use on the petition, along with the prevailing wage. And we'll also give some guidance on what maybe the concurrent petition could include as well. After that process, we contract, and then we go through petition development. And I'm going to, on the next slide, go into a little bit more detail of what happens during these processes. But from petition development to filing the cap exempt H-1B to starting of employment, typically is between usually around 8 weeks, maybe up to 10 weeks, sometimes as little as 6. It can kind of depend, right? So once the concurrent petition is filed, though, this is a really important thing to know. As soon as the concurrent petition is filed, the foreign national can begin working on their H-1B for their employer, okay? Because they're allowed to work while it's pending approval. So our petition is approved, we onboard you into the fellowship, and then the concurrent petition is filed and you can return to work, okay? So what is involved in this timeline, right? So in terms of petition development, the foreign national works with Michael and his team to go through the process of building the framework, not only of the petition, but also the framework of the project that they are going to be leading, okay? This is where the fellow is going to have some deliverables, ideating their project, putting together their project scope, things like that. We have guidelines and templates for this entire process, but because the project is specifically unique to the individual, they are contributing and collaborating on developing of it. So during the first several weeks, we develop the petition, we develop the project, we file the labor condition application, we sign an offer letter with a nonprofit, and then eventually we get to the point where we actually file the H-1B petition. We file all of our petitions using premium processing. And so USCIS, when you pay for premium processing, has 15 business days to adjudicate the petition. If we don't receive a request for evidence, the petition approval occurs. We then onboard the foreign national into the fellowship. And then typically after a minimum of 1 day of working at the fellowship, that is when the concurrent petition is filed by the full-time employer. We recommend waiting at least 1 day for the concurrent filing because we have to issue pay stubs, employment verification, these sorts of things that go along with the actual concurrent petition. There's always the possibility that we could receive what's called a request for evidence. This is when USCIS basically says, hey, we want to take a closer look at things, right? Sometimes these requests can be seemingly arbitrary, right? Just procedural things. Oh, we want to make sure you submitted all the passport pages, like these sorts of things. Sometimes they can be a little bit more detailed. If you're coming from a day one CPT program, for example, right, they're going to want to take a look at the timeline and to make sure the math is mathing, so to speak, right? That you maintain status and everything kind of checks out. If we expect a particularly nasty RFE on a petition that we are considering filing, we certainly communicate that ahead of time. Very rarely have we gotten one where we weren't expecting it. That was very in depth. The ones that we get kind of arbitrarily are exactly that, right? There is some seasonality to USCIS issuing these RFEs, and we see the increase typically happening after June 30th, which is, the deadline for those H-1B petitions, increasing throughout the fall, and then around the end of the year coming back down to earth right now. So that's, when we're putting together a timeline, we hope for the best, but expect, like the worst, right? With regards to RFEs. Yash, your question, yes, we file all of our petitions with premium processing. Okay. So moral of the story is if your OPT is expiring or your J1 or whatever visa that you are on right now, and you're looking at doing a change of status petition and joining the fellowship, 8 to 12 weeks minimum timeline. A little summary here. Build Fellowship, we've worked with over 300 companies over the last 9 years. That are, use the fellowship as a way to retain or recruit talent. We filed over 500 H-1B petitions at this point with a greater than 99% approval rating. And I'm oftentimes asked, like, well, why is that approval rating so high? And to be perfectly candid with you, it's because we only move forward with petitions that we know are going to be approved. Okay. If there's any reason we think USCIS is not going to approve the petition, that's not something that we're looking to move forward with. We're not here to waste people's time or money. And honestly, if I sat here and this percentage was like 65%, you'd probably be at home being like, well, that's not very good, right? So we take the evaluation and screening process really seriously. We've trained over 5,000 university students and fellow projects. Last year alone, we almost hit 1,400. And so you've seen this in the previous slide, we're working with great organizations and providing a creative solution for those who are looking to stay in the US and continue to work and contribute to the growth of the United States economy and the organizations here. So what's the requirements and eligibility to join the fellowship? Almost the exact same as entering the H-1B lottery, bachelor's, master's, or PhD in a STEM or business related field. We do prefer that our candidates have at least 2 years of work experience in a related field to their studies. OPT work does qualify for that, okay? We also prefer our candidates have experience working with or mentoring students or peers. And then also you have to have a job offer from a US employer, okay? This can also be your own organization, as we mentioned before. If you're an entrepreneur, if you're a founder of a company, you can participate in the fellowship through your own organization, okay? And then there is a very real financial commitment, okay? So the fellowship has a monthly programming fee of $4,000, okay? Now, what does that cover? That covers everything involved in the actual visa process. So all of the administrative fees, including things like the labor condition application to the Department of Labor, USCIS filing fees, including premium processing, which is like $3,000 alone, right? All of the costs associated with the attorneys to prepare and file the petitions. If we receive a request for evidence, that's covered. If you have a dependent that needs an H-4 petition, that's included. If you move and need an amendment, if you get to the 3-year mark and need an extension, that's covered as well, right? And then obviously compliance, educational programming. And then when a foreign national works as a fellow, they are an employee of the nonprofit. And as such, they are paid for the work that they do. Just like any other employer, when we file our H-1B petition, we are filing especially occupation code and a prevailing wage. And we pay the fellows the prevailing wage associated with their specialty occupation code for the 5 hours per week that they are working. The average monthly earnings by one of our fellows is about $1,000. Okay. Now, prevailing wage is based on your specialty occupation and then the county and state in which you're living, right? And so if you're a software developer in San Francisco, you're going to have a pretty substantial prevailing wage. If you're a marketing manager in, I don't know, central Ohio, your prevailing wage isn't going to be as high, right? And so these are all taken into consideration, but $1,000 is the average, right? So what that means is out of the monthly programming fee, somewhere between 25 to 30% of that goes directly to the fellow on a paycheck from the nonprofit. Okay. So when you're taking a look at the numbers as a whole, the net cost to the benefactor typically is between, I would say, $2,700 to $3,000 when you're factoring in the compensation going to the foreign national. Okay. And then I always like to end these presentations with just like a nice little quote from one of our fellows. Here's Kataki. It's just great. We work with amazing people. The fellows that we work with do amazing things. Kataki is one of them. And it's just something where there's a lot of benefits to the fellowship outside of just retaining employment or like keeping your job. Professional development is one of them. Many of our fellows, the goal is to eventually maybe qualify for an O-1 visa, right? And so a lot of them kind of utilize the experience they have working at the fellowship to help bolster that resume. I can't say that it's a difference maker, but it's definitely something that reflects really positively there. And just the overall experience working with students and participating in the fellowship is really genuinely enjoyed by our fellows, right? So if this is something that you are here today because you're in need of a creative immigration solution, give us a shout. That's something that we're here for. Next week, I don't think I'm burying the lead here, but next week, if you follow the Build Fellowship on socials like LinkedIn, et cetera, there's going to be some exciting announcements coming about some new programs that we're going to be launching and offering. So keep an eye out for that. But for today, that's going to wrap up where we were at with talking about our Cap Exempt H-1B fellowship. Michael, did I miss anything? Was there any question that came up routinely that you think I should cover again?
No, I think you did a great job. And we got a lot of questions about how to pitch this to a potential employer. If you go to our website, there are a number of documents that we have linked there or included on the website, guidance documents that kind of give you some talking points to discuss the fellowship. My advice would be to be very well prepared when you go in for that conversation and just get them to the point where they are willing to meet with us and we can talk them through what the fellowship program looks like, what the contracting looks like, what the investment looks like, and the benefits of the program at a level that hopefully they'll be able to sort of understand and want to go with. So it happens all the time. Somebody also asked, it's very difficult to pitch this. How do people do it? Over 185 people have done it that are working with us right now. So it does happen. And we do have a lot of people who change employers midstream. And so we end up having to sort of go through this process with a second employer if you change full-time employers while you're in cap exempt status. So you just make sure that you know all the talking points and get them to talk to Ian or I, and we'll be able to help.
We'll wear them down. No,
yeah, we'll wear them down.
This is the conversation I have literally all day, every day. And so we do have some great resources that can be shared. I think approaching it like a conversation is the most important thing, right? Immigration is intimidating for even those who work in immigration all day long, right? It can be intimidating. And so, especially if you're working for an organization that doesn't have a large foreign national population on staff, right? You might be one of only foreign national on staff, right? It can be kind of intimidating to pitch something like this to a company. But I personally kind of pride myself in making this very understandable and digestible and walking through the process. And if you have a company that's willing to have the conversation, just know that you're going to have an internal champion with someone at the fellowship who's going to advocate on your behalf for why this is a worthwhile endeavor. And as I mentioned before, if you've already been working for the company as well, the cost of retention is always less than the cost of replacement, right? And that's a perspective that a lot of employers need to understand, is that if they lose you as an employee, what is the true cost to that, right? And the fellowship is not something that is going to be forever. It's something to uh, kind of create a bridge, so to speak, to a more permanent solution like a green card or an O1 or even a cap subject H-1B in next year's lottery, right? Every year we have probably close to 50% of our fellows graduate from the fellowship because they've won the lottery or gotten the green card or qualified for an O1 or whatever it may be. And so Michael said, reach out. We'll send you some documentation, some information that's very helpful. And then we'll schedule a call and go through it. So, all right. So we are at time. Thanks again, Michael, for joining. It's always a pleasure. Thank you everyone for attending today. If you had to cut out or if you want to share this presentation with someone who wasn't here today, you will receive a recording of this in an email sometime soon, hopefully. And then just on behalf of everyone here at Build, thanks for tuning in. If you have questions, you can email us at info@buildfellowship.com, or just go to buildfellowship.com and request some information, and we'll go from there. Cool.
Thanks, everybody.
All right. Adios.